here on the matter of Mr. Stephen Katsikaris. And the matter, just let Mr. Katsikaris come forward and we can have a seat beside the court officer there if he wishes.
Well, good morning, sir. Good morning to you.
Nice to see you again.
So Mr. Katsikaris' trial date was today. We were in 123 court, Your Honor, and during the process at the commencement before any arraignment, comments by Mr. Katsikaris led to the Crown commencing an inquiry by virtue of an application under 672.11 for a fitness assessment, whereby the Crown called Detective Kilby, the officer in charge, and in the midst of that process, having heard some evidence from Detective Kilby in chief, His Honor was of the view, Judge Young, that the matter should be traversed here. And so the Crown has fitness concerns about Mr. Katsikaris today. I would like to seek a Form 48, and I'm prepared to call Detective Kilby and provide some evidence as a basis for that. In terms of the application for the Form 48, I note that Ms. Christ is present in court, our duty counsel. I don't know if Mr. Katsikaris would like a chance to speak to Ms. Christ or be able to speak to anyone in terms of this application and this process. But I believe that he's representing himself and would like to continue doing that. But that's just my belief at this stage.
Yes, thank you very much. So what is the status then of the trial matter? Is it vacated?
No, there's been no vacating of the trial, but one of the things that was said, Your Honor, during the course of the open court process was that Judge Young was involved in a conspiracy, and so Judge Young felt it wasn't appropriate that he would be the trial judge, but there is in fact a second day tomorrow, and so the trial is more or less in limbo, with the issue being an issue of fitness, and the Crown is wishing to bring forward and feels obliged to. And I can tell you that the Crown is seeking a Form 48, and it's the Crown's application to be able to have them assessed today here in 102, between 1 and 2. And then we will take it step by step.
And I'm totally against this, Your Honor. The Crown is trying to basically derail this case. I also have witnesses I'd like to put on the stand before you that can confirm that there is a conspiracy, starting with my brother and my brother's good enough. My father's language is pretty tough to understand. So basically what it's about is Stitchcom. The Crown doesn't want to give me Stitchcom. He doesn't want me to represent myself. So he wants me to be unfit for trial. Now, just to remind everybody that I did see you for 4 months, Mr. Judge Clerk, and you even said I'm a brilliant, intelligent young fella, and all of a sudden I'm not able to be fit for trial, according to Mr. Flaherty. Now, I've been coming to court for a year now, twice a month, and then we need to get my brother on the stand because he was a witness to an event on July 28th where I was basically attacked with a SWAT team after having the surety issue that we brought to your attention that my wife was leaving the country, and next thing you know I was denied bail, thrown in jail, and they used explosives to blow down my door. And the Crown doesn't want to have me have access to Stitchcom because he wants to obstruct justice. And I'm well fit, I'm educated, I haven't been swearing, I haven't been cursing, I'm in respect for the court, I am a little bit frustrated. And what I said was, yeah, there is a conspiracy, and I have someone else here to clarify, a witness that was not only there present in the courtroom in 123 this morning, but was also present on July 28th when we were attacked with the SWAT team. So obviously, if you got to use the SWAT team and blow my door down and not show a warrant, there obviously is a conspiracy. And it all is because they don't want to give me Stitchcom. And also for the record, Mr. Flaherty is failing to mention that there is a doctor's video of Dr. Hogarth with the police, and I want that too, along with Paul Martin's video. And there's 50 pages still missing from the file. I can't go to trial and have a fair trial under the charter if there's so much of this stuff missing. My argument is I didn't ask to be prosecuted for a criminal offense. If people want to trump up charges against me and then cover up what we said, E. coli bacteria is in our water now, up in the city of Kawartha Lakes. then I have a witness to clarify that right now in a Cottage Association magazine, which will be presented to court when we do go to court. There is a conspiracy. They're trying to say that I'm not fit for court. I am fit for court, and I have the evidence. And once I get disclosure, I have disclosure for the Crown, proving that I have emails from Emmett Yo, who's in the disclosure file, admitting that I was accusing an inspector at the City of Kawartha Lakes of accepting a bribe and putting a sewage system on an edge of a 100-foot cliff. And the video is up on the internet. You can see this thing. You can't hide its illegal sewage system. So saying that I'm crazy about this is ridiculous. There's footage up about this. There's court documents. There's the new bail condition that Mr. Flaherty doesn't want to talk about. And I have a witness right here that can contradict what Detective Kilby, what he's been saying about a conspiracy. So there is a conspiracy. All I say is let's go to court, let's put all the chips on the table and let the truth come out. What they're trying to do is stop this from happening.
So the Crown's concern for fitness is not that Mr. Katsikaris doesn't understand the personages in court or their roles. It's the ability to give instructions that is the question from the Crown's perspective on the fitness issue. And
to whom? Yeah, to whom?
Well, it's still one of the bases of fitness. If someone can't meaningfully provide instructions to counsel, they can't meaningfully participate in their trial.
Mr. Flaherty.
Okay, just a minute, sir. You know how it works. You know
Yes,
I'm always
yes, sir. And you know when you stop me, I stop. Right? I'm always polite to you. There's no grounds for this whatsoever.
So that's
Let's
the
just hear
first.
him.
That's the
We'll
first
hear him out, and then I'm going to hear you out as well.
The other point is that it's the Crown's belief, based on what was set up in 123 court, that Mr. Katsikaris has some belief about the court itself and judges, Judge Young specifically, that Judge Young was part of a conspiracy. And so, of course, if the role of the judge is somehow interpreted or understood in a way that involves the suggestion of mental disorder and the inability to appreciate the role of the judge, that's yet another aspect of the grounds for fitness. And remember, the application for a fitness assessment is reasonable grounds to believe, because it's the Crown's application, that pursuant to 672. If you look to 672.11 is the provision that allows for the Crown to bring the application, and then there's direction provided in the subsequent section, which is 672.12, sub 2, sub B. The prosecutor satisfies the court that there are reasonable grounds to doubt. And so it's not a very high threshold, Your Honor, to be able to suggest that the accused's fitness to stand trial is suspect, and so then it allows for the assessment order to take place. It's not a burden with respect to the actual fitness. It's just the burden to be able to meet the test for assessment. And so what the Crown seeks is an inquiry into the relative roles of the judge to Crown, because I too was named in a number of conspiracies which go well beyond any bail condition. There was a suggestion that I too was implicated in the E. coli reality that Mr. Katsikaris is speaking of.
No, you're part of the hit on my house on the 28th. You signed the bail condition.
And that I was guilty of conspiracy to murder, Your Honor. And so that was a number of times said, and I'm prepared to call evidence in the application. If Mr. Katsikaris wishes to be able to call evidence, I would ask for an order excluding witnesses. And it's not perceived as an unnecessary step in this process here. There's a relative impasse at this stage on the issue of him being able to stay quiet in court, being able to know the roles of the relative parties, and also having that quality of being able to meaningfully participate, which in our language in terms of fitness is determined on the basis of the ability to give instructions. And so you're quite right in saying Mr. Katsikaris is self-represented. Quite right in saying there's not a real physical impediment to that step, because we don't have counsel coming forward saying, I'm afraid, Your Honor, I can't give instructions. But that failure to be able to give instructions is actually an inquiry in part into whether the person can follow the process without delusional thought or without some form of major mental illness impact precluding them from being able to meaningfully participate. And so it's only that inquiry, and remembering that the threshold is not one that is the same threshold that the Crown has to cross on the fitness issue. It is the Crown's wish to seek a Form 48, Ms. Beth.
Thank you. Mr. Kawartha, I know you're nodding your head and
this is absolutely wrong, Your Honor. You and I saw each other, I believe, from June till September or May till June or whatever it was, with numerous occasions. You always told me to stop in the courtroom. I stopped. I was always polite. You always showed that I can control. I always demonstrated that I can be controlled by the judge when you say, please, let him finish. And you and I had this discussion. And the only thing I was guilty of, Your Honor, was not knowing the actual protocol. Once you made it clear to me, I behaved myself. And what the Crown is now, and when there is a conspiracy, the problem I have is when I'm trying to get disclosure for a full year, and if I've done something wrong, you should show it in 3 to 7 days according to Stitchcom. This has been a full year now, past a year since the charge. I'm missing 50 pages. There's a doctor sworn statement that she's accusing me of a crime, supposedly. I haven't seen it yet, so I'm not passing judgment on her. And the Paul Martin video, Police Chief Paul Martin. He's also my next door neighbor, and I really believe the Crown's trying to derail this case any way he can and basically discredit me. Now, I have the right as a citizen of this country for a fair trial. I can't have a fair trial if the Crown and his court are going to start covering things up. And just for the record, Judge Young has now washed his hands with this, Mr. Judge Clark. He is now gone. He said he's not doing this case anymore, and he said bye-bye, go down to 102. So I just want to let you know that Judge Young is not happy in doing this case either. He's now out of here. He's gone. So he wants someone else to do it. So let's just follow the law. Let's go with Stitchcom, follow the law, let's have a fair hearing, and all this evidence will come out. And if the Crown wants today, I have a witness here that will confirm my story about conspiracy. And he was there on July 28th, and he was the one that cleaned up the glass from the explosion that blew down our door without a warrant. And I was basically almost killed. So we got a real serious problem here. And that's why, Judge Clark, we need to go to trial so we can sort this out so that someone doesn't get hurt. That's what I'm worried about. Public safety, the police safety. I'm mad at them, but I don't want to see them get hurt. But if we keep playing this game, it's going to escalate and escalate and escalate, and I don't want that. We need to have a trial with a jury so we can get it all out there, and who's ever done wrong, me or the police, it will all come to truth. But to let me be pushed aside because of this theory, which the Crown has no bearing on it, he has no psychiatric report to even be in 102. I was here in 102 on April 11th. I have a Judge Red Sash order to give disclosure. It's on the record on April 11th. Sorry, I just need to take a breath.
Okay.
And I want to say there's a lot of injustice going on here.
All right, let me just stop you there for a second. I heard you say something about a jury trial. This matter is not going to go before a jury. You're in the Ontario Court of Justice, sir, with a judge alone. And listen, let me stop you for a minute. Let me talk for a minute.
Yes, sir.
You and I do know one another. We've been through a lot here, so I'm not speaking in a vacuum here, okay?
Yes, sir.
You've never mentioned jury before, so
yes, sir, I did.
Let's get serious here. The last time we dealt with one another, you knew that this matter was going forward to be tried in this level of court, correct?
That's correct.
Okay, so let's just stop. That's another issue.
Okay.
I want to make it clear to you, you're not getting a jury trial here. Is that understood?
I can agree with that. Okay.
Thank you. Okay, so let's move. Were you ready to proceed to trial today?
No, I wasn't.
And so you made a preliminary motion to Justice Young, did you, to say that I'm not ready to go because I'm still waiting for this Stinchcomb disclosure of...
And bring in witnesses. I have witnesses to bring in, and I haven't been allowed to bring any witnesses. How can I have a trial if I can't bring in my witnesses, and the Crown's witnesses didn't show up?
All right, well, you understand, we've talked about this before, the way it works, the way it unfolds with a trial is that the Crown has to go first, right? The Crown has to call all the evidence against you. And then if you're in a position of either being taken by surprise or that you have witnesses that you'd like to bring to respond to the evidence that you've heard from the Crown witnesses,
yes, sir,
then I would think that the presiding trial justice would give you an opportunity to do that. So you're not going to get everyone under the same roof at the same time with all your witnesses. It'll have to go step by step.
That's correct.
That's another issue. We're here now because Mr. Flaherty is asking me to give consideration to yet another dimension to this matter. So let me just ask you a couple of things that I think I already know the answers to.
Okay.
You know what the charges are that you're facing, correct?
Uttering a death threat.
Yeah, and you've known that every time that we've had an exchange with one another all the way through.
That's correct. And that's an allegation of a death threat, just for the record.
Well, we understand that.
Yeah.
Nothing is carved in stone until the Crown has proven the essential elements against you. But you know clearly the charge you're facing, correct?
That's right.
Right. And you also know, in a general sense, the consequences in the event that you're found guilty of this.
That's correct.
Right? And you know what the decisions are that a trial judge would make, right?
That's correct, sir.
There's guilty, and what's the other one?
Not guilty.
Right. Okay. And you've always indicated. Fair enough. You've already indicated to the court throughout any of my dealings with you that you intend to represent yourself, not by virtue of not being able to retain counsel, but by choice.
That's correct,
to represent yourself, correct?
That's correct, sir.
So you wouldn't be instructing anyone other than yourself.
That's correct.
Okay. Thank you.